Our breakfast speaker this morning is Dr. Michael Schaper, who is Deputy Chair of the Australian Competition and Consumer Commission, the organisation that oversees these issues and competition law in Australia. Dr. Schaper holds a PhD and a Masters of Commerce degree from Curtin University, so he's been educated in Western Australia, so we know where that comes from, as well as a Bachelor of Arts from the University of Western Australia. He was appointed to the Australian Competition and Consumer Commission in July 2008 as its Deputy Chair. His previous roles included ACT Small Business Commissioner, Dean of Murdoch University Business School in Western Australia, and Head of the School of Business at Bond University in Queensland. He was also previously President of the Small Enterprise Association of Australia and New Zealand, and has been a member of the Board of Directors of the International Council for Small Business. He's an author and co-author of 8 business management books and has been a regular columnist in a number of national magazines, newspapers and journals. He's also worked as a policy advisor to government at both state and federal levels. In asking Dr. Schaper to address our conference today, we're particularly interested to hear his views on whether Australian competition laws too narrowly focus on protecting consumers without providing any protection for suppliers, such as farmers and processors. So we look forward to hearing Dr. Schaper's views on these and related issues. Thank you.
Thanks, Mick. That's a, whoops, there we go here. I'll leave it over to the AV, the first test there. That's a suitable introduction, I guess, and clearly shows me where the questions are going to come from at the start. Look, thank you for the opportunity to come along and talk to you. Clearly, much of what we do is of interest to many of you, and as one of those organisations that has a fairly wide remit, I'd probably be surprised if there wasn't at least someone in the room that had at least one or two searing questions for me. I'm going to get to the point that Mick raised there a little bit later on, but principally what I want to do today, given that our ambit is fairly broad, extraordinarily wide, and covers just about most aspects of agriculture broadly defined in some way or another. We touch on it in one way or another. What I do want to do today is really run through 3 or 4 hot button issues that we're dealing with at the moment, namely collective bargaining, the Horticulture Code of Conduct, country of origin labelling, and wheat exports, before touching on the issues that the Mick raised there. And of course I'm very happy to take questions either as we go or probably more easily towards the end. So it's not a test. Mick referred to the fact that I'd spent several years in academia. It's a long, complex piece of law, but don't worry, there's no test at the end of it. So let me, first of all though, give you a rundown about who we are and what we do. One of those organisations that is well known in the public media, that frequently pops up in your worst nightmare in A Current Affair or Today Tonight about killer toys and all manner of other things. But really, we as an agency are a statutory body that have 3 essential functions: consumer protection, the general maintenance of competition law as handed down to us by the Parliament, and the regulation and management of specific key industries where some particular monopoly or highly concentrated market power exists, and where the Parliament has already legislated to give us particular powers. So the Competition and Consumer Act, the old Trade Practices Act as it was once known, is a long, complex body of law with many, many different parts to it. But essentially they're the 3 elements: competition management, consumer protection and regulation of key industries. Now there are a couple of things to note about not only the Act but also the Commission. We're an independent statutory body. We have 7 commissioners, myself and 6 others, who administer the work that our roughly 700 staff do. We have offices right around the country, including not only one in Brisbane in this case, but also one in Townsville. But our core focus, and this alludes to the question that Mick did start off with, is unashamedly a concentration on consumer welfare. Consumer in the broadly defined sense, that is to say the general public. So our ultimate objective is the advancement and the interests of Australian consumers, and to that end it also entails many of those hard decisions about, are you looking after competition, or are you looking after the competitors within the process as well? Now, one of the misconceptions that often exists about the work that the Commission does is our role, and unlike some of our European counterparts, basically ours is a judicial enforcement model, which is to say that although there are parts of the Act where we can exercise a discretion, there are many parts of the Act, for example, prosecution of cases under the general consumer provisions or the general competition provisions, that ultimately have to be decided in a court. In contrast, a number of European jurisdictions and other parts of the world, agencies like ours have a range of other powers. For example, in some countries they have divestment powers. They can direct companies to break up if they cross over a certain threshold. That's not the case in Australia. And despite what is often said, we're not a policy agency, we're an enforcement agency, which means that our focus is on working with the law as it's been handed down to us by the Parliament, rather than necessarily this is what the law should look like. It's very important for a policeman of any body of law to actually spend their time making sure the law works, rather than spending their time saying what the law should be instead. So let me run through a couple of areas. I'm conscious of time and I want to try and keep it relatively concise so that you've got plenty of time to raise any questions that you've got. I mentioned that there are many different areas. I've raised a few, and I haven't in this presentation mentioned a few of the others that are also part of our brief. So for example, today we are responsible for setting down the water trading rules in the Murray-Darling Basin. We are responsible through involvement in activities such as certified trademarks. Some of you will be familiar, for example, with the free-range egg decision recently, those sort of things. I'm not going to touch on those in the presentation, but again, happy to take questions on them if they come up. So first one I want to talk about, though, is collective bargaining. So this is a quick potted guide to some key aspects of the Act and our work and how they impinge on the agriculture sector. Generally speaking, the law is framed in such a way that competitors can't collude, share information that might be market sensitive, or operate in a way that seeks to lock up a market. Price fix, for example, cartel arrangements. However, unlike many other countries, we do have a specific provision that does allow small independent traders to come together from time to time, and if they can show us that there's ultimately a public benefit, to get basically our shield of protection from prosecution under the law for jointly negotiating prices and such like supply terms and so forth. And this is usually an arrangement where a number of small individual firms, for example, or small farms, come together and jointly negotiate terms of supply with a much larger firm. So a collective bargaining arrangement. Interestingly enough, the law actually also allows these firms to collectively boycott, but that provision has never been upheld at later stages. So collective bargaining is one of those arrangements that we are involved with. There are, in the last 5 years, there's been roughly 80 of those that have come through, and about a quarter of them have taken place within the agriculture sector. And you can see up there a list of some of the industries that it applies to. Chicken growers, potato growers, we've done tomatoes as well, dairy farmers. There's a variety of other ones as well. Just earlier this month, for example, we authorised a group of both Victorian and South Australian potato growers to jointly negotiate with their supplier as well. So this is a fairly useful tool that allows businesses to come together, negotiate as one block with a supplier, and hopefully in the process win themselves some better terms and conditions, but also create some economies by being able to do it as one rather than being left to stand alone. So that's a fairly important tool for many firms in terms of trying to redress a bit of market imbalance between themselves and a larger supplier. One of the other ones that we do also deal with is the Horticulture Code of Conduct. This has been around since 2007, and it's one of 4 at the moment mandatory industry codes of conduct that the Commission is responsible for policing. Now, like most of the codes of conduct, the primary emphasis here is on information and mediation. The Horticulture Code of Conduct applies principally to unprocessed foods, fruit and vegetables, and it basically involves a process in which growers dealing with either merchants or traders, either agents selling on their behalf or selling directly to final term traders, get a requirement for a disclosure of information, access to mediation if there's a dispute about the terms of trade. And it arose several years ago out of a concern from some horticulture growers that they basically weren't being given the full range of information about the terms and conditions of their contracts. They weren't getting contracts as and when they were selling goods, and that if they had a dispute with their merchant, there was nowhere really for them to go. In other words, they were pretty much held over a barrel in terms of their capacity to deal with it subsequently. So the code here gives fruit and vegetable growers the capacity to rely on getting access to information, namely a horticulture produce agreement, access to mediation in case of a dispute, and a more clear and transparent process about understanding the terms of trade under which they're dealing with. The Commission also has powers to audit this, and over the last couple of years we've had that audit power for almost 2 years now. We've only audited a small number of horticulture producers, but of those 7 or 8 that we've done, only one of them has shown any sort of substantial breach of the law. But we are continuing to look at it, and it is one of these areas that doesn't get a lot of attention outside of those directly involved with it, but it still plays an important role within that industry itself. Country origin labelling. This is one of those areas that does attract a lot of attention, and it's certainly one in which the Commission has a role to play, not only in making sure that the laws are policed, but also in making sure that people and consumers are aware of them, and I think in some respects also driving consumers to become a little bit more aware about what they're going. Now, I think in Australia there is a big disconnect between what people want to buy and what they think that they're buying. I think that there are numerous occasions in which Australians are very proud to wave the flag and say, I want to buy Australian. The question is, what exactly is Australian? And it's not one that they find easy to answer. So the country of origin labelling rules put in place a bit of a framework to help make that clearer. It doesn't, I think, give it 100% clarity. There are still plenty of opportunities for consumers who don't fully get their head around it. And let's face it, we're all busy, we've all got many things to do in our lives, but it does provide a starting point. And in turn, the better informed I think Australian consumers are about what those labels are, the more likely they are to demand or seek out or deliberately purchase Australian produce as well. So essentially there are 3 elements: product of, grown in, and made in as well. Product of and grown in are basically one and the same. The only difference between those 2 particular labels is up there. One is for fresh food and the other one is for processed food. And basically most of the production process is done in Australia. And you can see from the examples we've given up there, for example, salmon, caught in Australia, smoked in Australia, packed in Australia. That's a product of Australia, fairly clearly. The other 3rd label that people sometimes come across is this idea of made in. And made in does produce, I think, perhaps a degree of uncertainty for people. Made in the country claimed at least 50%. This is a much lower threshold than the other 2. And what it really does mean, as you can see from the visual up there, made in Australia from local and imported ingredients. Now, there are often good times why businesses mix up their ingredients. For example, to meet seasonal fluctuations with a steady consumer demand, but supply only comes in on a periodic basis locally, so you have to supplement it, for example. But this is the one where consumers do run into some confusion, and in many respects they often think that made in means that it's completely 100% Australian. So we're trying to run a bit of a campaign at the moment to improve the level of knowledge about country of origin labelling. It's not a particularly easy one. I think having some standard terminology makes a difference, but it's also one in which I think perhaps more involvement from the sector will also ultimately result in more consumer demand being expressed for Australian, for local produce as well. The next area the fourth area I want to touch on very briefly is this area of weed exports. Back in 2009, when the decision was made to get rid of the single desk for weed exports, it was also very clearly recognised by government that weed export arrangements would only be functional if those who operated ports didn't and had that access to the bottlenecks there, and who had an involvement in the industry itself, weren't able to give themselves preferential access to exporting arrangements over and above other traders who might also want to export. So the weed export access arrangements are one of those areas that under the Weed Export Act have been given to the Commission to look after, and what that's involved is us certifying effectively from four major suppliers weed access arrangements that put in place a set of protocols to ensure that other exporters can use port facilities and can do so on relatively fair terms. Now, this is an industry in transition. Even as we speak, of course, Parliament is debating a proposal to replace even these existing arrangements with a mandatory code of conduct. I mentioned codes of conduct earlier on. That is still in Parliament at the moment. But the key issue here is about making sure that exporters have access to ports, and that where access seekers have difficulties with port providers, that there are the following sort of arrangements in place. Information about how the port will allocate facilities for exporters, how prices will be set, the ability to arbitrate and negotiate on those prices, and to sort out where there are disputes between the exporter and the port, how those will be sorted out as well. So it's been a long, complex process. We've gone through effectively 2 rounds of access certification with those 4 major suppliers, and we'll be continuing to deal with that. But of course, at the moment, it's a bit of a watch this space arrangement. Now, so there are 4 areas that we very briefly touch on: collective bargaining, weed exports, Made in Australia, and the Horticulture Code. Mick also mentioned in his opening comments, and also in the letter of invitation that came out, this question about concentrated markets, and also about whether or not it's the Commission's responsibility to look after the interests of firms as well as consumers. Well, I think there's probably a couple of comments to make on here before I touch on this area. First of all, we do believe very significantly that the Commission has a role not only in looking after primarily the interests of Australian consumers, because Australian consumers are, after all of us. We also are very conscious of the need that small businesses, whether they be small agricultural enterprises, retail ones, wherever they sit, also suffer from marked imbalances in the marketplace compared to their much larger competitors. And we have a number of provisions. Collective bargaining is only one of them, which is designed to help ensure that small businesses can compete fairly and get a reasonable chance to compete. By and large, the way in which both our law is structured and the way in which the Commission works is on the assumption that we don't seek to necessarily give preferential treatment to a particular firm, but rather to ensure that there's effectively a level playing field, and so businesses can rise and thrive, or indeed fail, but they do so on their own merits and not because the rules of the game are fixed against them. And that's always been one of the enduring concerns. How do you make sure that the rules of the game are fair so that existing businesses can compete, new entrepreneurial businesses that want to come into an industry have a chance to do so? But at the same time, the big challenge is also to make sure that you don't turn an economy into a sclerotic economy, that you don't turn it into one in which innovation or change, in which new players who can upset the existing order and maybe bring about some new innovations aren't denied access to it. Now, 2 of the areas in which we're often asked to make comment, and which in many cases people often say that we should be doing more, are these 2 areas behind you: misuse of market power and unconscionable conduct. Let me just run through briefly what they are. Misuse of market power is a term in which it comes quickly to mind about what it might be, but in terms of the law and what it actually is and how a court interprets it, it's somewhat a different creature. Misuse of market power is one of those terms everyone thinks they know what it means, and depending on where your situation is, has a multiplicity of different determinations about what it could be, about what's a misuse of market power. The law is very clear on it, and it has three key elements. You've got to have a market power. We don't, unlike some countries, have percentage figures. I've just come back from Malaysia, for example, and there they have a figure that says if you have over 60% of the market share, you're deemed to be the dominant business in that market, full stop, end of story. We don't. So, you know, it is entirely possible that you can have a very large market share and have a large amount of power, but equally you can have a much smaller share of the market but sometimes still exercise power in all sorts of other ways. Secondly, you've got to not only have power, but you've also got to take advantage of it. You've got to rely on it. And that's a bit of a harder test. And the third element is that you've got to have done it for a purpose. It's not the impact, it's the purpose. Did you deliberately set out to misuse your market power? And that's a much harder proposition to prove. Did a firm deliberately set out to misuse the power? The fact that you've got power, the fact that you're the biggest one, for example, the biggest firm in a particular industry, doesn't make you guilty automatically. Nor the fact that your actions may have driven someone else out of business. That doesn't make it a breach of the law automatically either. You've actually deliberately have gone out with the purpose of trying to achieve that and used powers that others don't have in order to get anywhere close to satisfying that test. Most of our cases on misuse of market power have almost invariably been against very big firms who've got considerable legal resources, as you can imagine, and the number of cases that have been fought on this matter and decided in the courts is very small. They're very lengthy, they're very time consuming, they're very expensive ones, and they're very difficult thresholds to convince a judge. As I said, we don't as a commission have that power to make a decision ourselves. We basically have to give it to the court and let a court decide. Second one is this idea of unconscionable conduct, which is basically, are some firms doing things that go well beyond what is normal hard bargaining, normal rough and tumble of business dealings, and go so far beyond the pale that, as it says up there, are not right or reasonable, don't have any regard to conscience. Again, a very subjective term, and there's a small-scale franchisee who has just had a very tough series of negotiations with their franchisor, might regard themselves as being a victim of unconscionable conduct, but a judge may well not. So they're very hard tests to satisfy. So in terms of where we sit as a commission, first of all, the most important thing for us is to make sure that the process, the competitive process, is open. The second thing is that where we do think that there's been a breach of the law in some of these areas like unconscionability or misuse of power, there's a high set of thresholds that we have to jump in order to be able to prove that as well. Now, there are a number of other areas that I haven't touched on briefly. I'm conscious of where we're at with our time, Mick, and I realise also probably there's plenty of questions. I haven't covered so far, for example, issues like our approach to mergers and acquisitions. As I mentioned before, I haven't today gone into any detail about our work in other areas such as water and so forth. But I think I might, just before I throw it open to the floor, Mick, herald these three things. These are three of the areas at which we have said publicly we're looking at. Now, these are complex matters. They require a high evidentiary burden, and they're a complex mix of interaction of both economics and law. So there is, these are taking time, and there's no shame in that, because I think you need to get them right rather than get them done quickly. But these are three areas that we have said publicly we are looking at. First of all, the treatment of suppliers by major supermarket chains. This has been an enduring issue that is raised not only time and again with us today, but stretches back 3 or 4 years ago. You may recall we did a major inquiry into the state of competition in the supermarket industry back in 2008. We continue to receive concerns from suppliers about their treatment by those major chains, and we are looking into it. Second one is another hoary old chestnut, petrol, fuel retailing, and more importantly, the process of sharing information. economists will tell you the more information you put out, the better it is for consumers. But there are also certain practices that take place in the petroleum retailing sector, whereby petroleum retailers share information, and whether or not that actually breaches the law is an issue that we're looking at as well. And the third one, again, which is actually a bit of an interplay of the other two in some respects, because it covers both petrol and supermarkets again, is shopper dockets. Shopper dockets are one of those issues that raise passions both ways. You get a lot of Australians who are deeply wedded to their shopper dockets. They love their shopper dockets. And you get also another group of people who say makes it really hard for us as independent supermarkets to compete, or as independent petrol stations to compete. And so we're looking at the implications of that as well. Been around for a while. So, as I said, complex matters, ones that will take a while to get through. Now, I'm conscious of time, Mick, so I think I might... so there's a very quick potted rundown. Fortunately for you, you haven't had to do the 2,000-page book that I got when I walked into the Commission and said, what do you do here? And I got given a copy of the Trade Practices Act, all 2,000 or so pages of it. There's your annotated version, off you go. But hopefully it does give you a quick overview about some of the key things that we are doing. Happy to take questions, and happy afterwards also. I should also mention we've got one of our Brisbane staff members down the back, Aggie Roosen. Aggie has just turned up for this morning's session, and if there's anything that we can't help you with immediately, we'll be happy to take any of your comments and deal with them afterwards as well.